Mr. Shaw.
Good morning.
You want to just wait a minute until... you may proceed.
Chief Justice Marshall, and may it please the Court, my name is Robert Shaw. I'm privileged to appear this morning on behalf of Peter Stuckich. The many issues in this appeal arise out of judgments for indecent assault and battery. I will first address the very significant first complaint issues, and while I suspect that may take up most of my time, if not all of my time, it is certainly not my intention to diminish the importance of or our reliance upon the 5 other issues that have been briefed, which we contend demonstrate a pattern of prosecutorial overreaching and misconduct that resulted in a very unfair legal proceeding.
Could you give us a quick summary of how many, quote, complaint witnesses you say there were?
Well,
I know there was Barbara, I think her name is Barbara Horan.
Right. Well, if we get to what we contend are the actual complaints, there was one to the mother, there was one to the other individual living in the home, there was one potentially to the counselor. If you look at what was family therapist, I should say. If you look at what was presented at trial, we have the school counselor. The school counselor mentions the principal comes in. There is 51A filed with DSS. DSS then moves for a care and protection proceeding, which was part of the trial evidence as well. We have a restraining order. We have a judge making a determination based upon the restraining order. We have a complaint to the DA's office. We have a complaint which would have included the Millis Police Department, the state police. We then have further proceedings concerning the
so
care
all
and
of these
protection.
you would say are in one way or the other fresh complaint type of evidence?
Well,
clearly the restraining order is not. That's just a document.
Well, it consists of a complaint being made concerning the alleged actions of the defendant. But I think that the first issue is really the designation of the first complaint witness.
And who do you say the first complaint witness was?
The first complaint witness was the mother.
And was there evidence to that effect? What was the testimony at trial, for example, by the complainant?
Well,
who she first complained to?
Right. Well, the testimony she said that the testimony provided evidence that there was a complaint to this school counselor.
But the letter...
Was there testimony at trial that there had been a prior complaint to the mother or the doctor or the brother's friend?
No, because what happened is that the judge said the first complaint is going to be to the school counselor, and then defense counsel was put in a position of...
But defense counsel could have asked the victim when she was on the stand, did you previously complain to your mother, the doctor, the brother's friend?
Right, but what good would that have done him? And
at least established a record. But
did the victim testify here?
Isn't the main problem here that the judge simply didn't have a hearing? I mean, there's a problem that we have to state what the law is going to be as to in this type of a circumstance. But aside from that, isn't the problem mainly that the judge didn't hold an evidentiary hearing, so we don't know whether the mother lost her memory?
Right.
And other people were, in fact, complaining.
Exactly. And I think that's the first issue. If I could just address that in a focused way fairly quickly here. Designation of the first complaint witness is essentially the issue. And I think before we get into questions about what King requires or the larger policy considerations of a decision in this case, this can be resolved on an abuse of discretion analysis alone.
Not holding a hearing.
Exactly. Because what you have is that there were these highly emotional writings. The government wanted to get them in. The problem for the government is that the writings themselves say they're not the first complaint. There is other discovery and evidence read into the record, undisputed by the prosecutor, which indicates that there was an earlier complaint 2 months earlier to the mother, to another person living in the home, and potentially to a family therapist.
Mr. Shaw, can I ask you this question? Was there any suggestion that this child had delayed reporting what had happened to her?
There was some delay. There was some delay even if one looks at what we contend was the actual first complaint. Yeah, there was some delay.
Years of delay.
Right, there was some delay. Sure. No, that's not the issue. And you know, the first issue is this designation issue and the fact that there was no hearing. The court can look at the unresolved questions here and determine that there's been an abuse of discretion. For example, was there a real loss of memory? Was it fabricated? Was it real? If it was real, could it have been refreshed? If it couldn't be refreshed, was it partial or was it total? Questions arise concerning how is it that the complainant, the mother, this other person living in the home, all of a sudden had a loss of memory right before trial. There's a question concerning if there was a disclosure of this nature and magnitude, why was it forgotten? And if it was forgotten, isn't that probative of what was said?
May I ask you, did the Commonwealth suggest to the judge that the reason for having the family counselor be identified as the first complaint witness was because they were unavailable, the other people were either unavailable or were not able to testify so that the judge could exercise discretion?
Well, and this is very important because really what the prosecutor said was that, well, it's my understanding that this is what the evidence is going to be. And I would ask the court to look very closely at the hearing on November 2nd of 2005, page 29, where what the prosecutor says is that the alleged victim, quote, makes it pretty clear to me, unquote, that this was the first complaint. And then at page 33 again says that the witnesses, quote, have no independent memory, unquote.
But did the Commonwealth ever suggest why the other people, the mother or the friend, were not available? That's my question.
Beyond what I've said, no, not really. In other words, the defense had this supported, undisputed evidence consisting of the first the letters themselves plus the other discovery, and yet the judge ruled in just a leap in favor of one side without any probing analysis and without any voir dire witness.
Now, the letter that the juvenile sent to Mrs. Horan includes reference to the fact that my mom did not know anything about this, but I recently told her.
Exactly. Exactly. So
was there a discussion about that part of the letter with the judge?
Yeah, the judge acknowledged that it existed, but the judge still leaped in favor of the prosecutor, despite the fact that there was no contrary evidence indicated. And I would also point out that if the court looks back to the Bishop hearing, a very brief hearing that occurred on February 15th of 2005, the prosecutor made an argument there which really assumed, it was implicit within the discussion, that the mother had known about this and had had a discussion with the family therapist about this. During that hearing, the prosecutor referred to Ms. Horan as the fresh complaint witness. Then this court came down with the King decision, and it turned out that fresh complaint wasn't going to work anymore, and now we get up to trial, and all of a sudden there's a loss of memory, despite the fact that there's all this contrary evidence.
Let me ask you this question. Assume that we agree with you that the judge should have held a hearing. Does that make it that because the judge, I guess it was a man, it was a woman, because she didn't, does that then make it impossible for us to draw any general principles from this in order to enunciate a rule developing King, because we don't know what the mother would have said?
Well, I certainly don't think so.
Do you think that, are you suggesting that we should develop a rule that it is the first complaint witness, even if that person is, has unfavorable evidence to the Commonwealth?
Absolutely. I mean, I think that this case really puts forward the issue of, is the first complaint doctrine the first complaint doctrine?
Well, we got the issue of is it or isn't it? It's also in the next case too.
Right.
But is this one of these cases where we could remand it and say to the judge, we're going to hold off on deciding much of anything unless we decide there's something else in the other issues that might require a new trial? But assuming there's not, and I'm not saying there is not, hold this hearing, get the mother in there, go through all this and see if in fact there was a loss of memory, and then come back up here again?
Well, I suppose...
We've done that from time to time.
Well, I suppose that that's possible, but I don't think it's the proper remedy. I mean, of course, our position is that there are 5 other very substantial issues in the case that justify
No, I
reversal.
said, yeah,
Okay.
if we get a reversal on one of those, then it's academic, so to speak.
Right. And I think that there's a lot of prejudice that occurred in this case, and a lot of time has passed now, and the evidence is really overwhelming that there were earlier complaints. And I think the question is, given the fact that there were these earlier complaints, if there was a loss of memory, which is a fairly extraordinary assertion, isn't that probative?
It may very well be, and I think it's your position that there are multiple complaints were admitted in evidence here, which goes well beyond what the King
that's
case
another
said.
That's another aspect of
I
the case.
take it
That's really the second issue.
What you're looking for is a new trial. So I take it if we say, in this case, there should have been a voir dire to determine who was the first person to whom this victim complained, that could be dealt with at a new trial. And if we conclude that there was too much evidence, too many occasions in which the Commonwealth introduced in evidence what this victim was saying to various people, that can be cleared up at a motion in a new trial, correct?
Yeah, and I think that the court could also address it in the decision here. And I think in addition to looking at this in terms of an abuse of discretion, the court can look to the King case and note that King says it is the prosecution's burden to establish substitution. Here, the prosecutor did not even mention substitution in the motion in limine.
Mr. Shaw, was all of this objected to when we look at this record?
The first complaint, designation of the first complaint witness was objected to. The second issue concerning first complaint, which were the multiple fact of further complaints, the mechanisms by which those complaints were received, and the responses to those complaints, was not objected to. And there were several other objections to the other issues in the case. But I would really ask the court to look also at the development of the doctrine here. I think that if the court was to accept the Commonwealth's position in this case, this is really going to become the best complaint doctrine, or the preferred complaint doctrine. And the effect of that is going to be really what occurred here, which is that the actual most relevant circumstances surrounding the disclosure are going to remain hidden.
We have that issue in the next case. You're aware of that.
I do, although it seemed to me to be far more limited.
Or confined.
More confined, exactly.
What did you call this? If we agree with the Commonwealth, you refer to it as the best complaint doctrine?
Exactly. This is going to become the best complaint doctrine, or the preferred complaint doctrine. And what is going to happen is that the relevant circumstances surrounding an actual disclosure are going to remain hidden from view unless a defendant is willing, during trial proceedings, to not only listen and deal with the asserted first complaint by the prosecution, but then go upstream of that and bring about even more information about earlier complaints.
Surely you would agree, if there's a proper foundation in the record, that the Commonwealth can resort to someone other than the, quote, first complaint witness, if warranted.
If warranted, if a substitution is warranted.
Suppose this loss of memory is documented at a voir dire, then you go to the next one.
If there was truly no memory and there was unavailability, then probably that.
Or, as the next case possibly raises, the first complaint witness is really an adverse witness to the Commonwealth.
Right.
Because she's taking different contradictory positions on what she was told and what happened.
But the other thing I want to point out is that even the government and certain advocacy groups, as I understand it, don't want to live with the first complaint doctrine. And I understand that the primary reason for that is likely that an initial disclosure is not going to be perhaps the best or most complete disclosure.
Will we have to have a hearing in every case to reach some agreement on who the first complaint person is?
I don't think that it's going to occur in every case, but it may occur in some cases, and certainly in a case where there is a lot of contrary evidence, there needs to be some sort of hearing or some sort of
well, perhaps you could say
determination.
something like, although it's the Commonwealth's burden to establish a substitute witness, all right, then they would have the burden to establish that the first complaint witness is not mentally competent or whatever you want to
Many
say.
times it's going to be the police. You know, they'll want the police because, you know, the mother is told, well, by the daughter or whoever it is, the uncle is doing this to me, and the mother, of course, goes ballistic and can't think straight, and the next thing she does is she brings him down to the police station, and
Right, and
officers brought in, and then
Mr.
gets a
Shaw.
very detailed record, and they'll want that witness, not the mother.
Right.
Is that okay?
Shaw, may I ask you this question? Was there any aspect of the defense in this case that this was fabricated because this child had not told anybody for several years?
No, that was not an allegation of the defense.
If the purpose of the first complaint is that if the primary goal of letting in this evidence is, and I'm quoting, to refute any false inference and silence as evidence of a lack of credibility, why does the issue even arise if that is not part of the defense?
Because this court has said in King that the government can do this. And I think it's very...
Should we rethink that? In other words, if there's no claim here, if there's no claim, no defense, no suggestion, this was fabricated, and as an element of fabrication, as one way of showing fabrication is because, look, she didn't say anything about it for 10 years or 2 years or 3 years in this case.
How can you say there's no fabrication? His testimony was he never did it.
Well,
so the inference has got to be it was fabricated.
But Chief Justice Marshall, you just indicated, was there a defense focused upon the delay? Clearly the defense was that it didn't occur. I draw a distinction between those two things. And to answer your question, I would say yes. I mean, I think it would make a lot of sense not to allow all of this information right from the get-go in the prosecution's case in chief when there isn't going to be that kind of attack on credibility concerning delay. And I think it's very important to realize that every other jurisdiction in the country does not allow in more than the fact of the complaint because the original purpose of this is simply to rebut the risk and the presumption that the court has made in King that there is still a risk that silence might be inferred as a lack of credibility.
Thank you, Mr. Shaw.
I have a question, if I may.
Of course.
And your answer may take too long, and if it is very convoluted, just say so and we'll forget it. But and it's on a different issue. I had a difficult time understanding, and maybe I just didn't spend enough time on it, your claim about the testimony from the other hearing, the C&P hearing. Can you explain that briefly, or is it very complicated?
No, I can explain it briefly. Are you asking about the Crawford aspect of that?
The aspect, no.
The fact that there was an admission?
I have, no, not the fact that the victim's mother testified rather than the transcript, but what was there from that hearing that was inadmissible? And what you say was inadmissible, and why?
What happened is that, well, to begin with, I think DSS moving to terminate rights should never have entered into this proceeding at all. That is so extraordinarily prejudicial, it's really unbelievable. To show a sequence of events where DSS is notified and then they move to terminate rights, number one. But number two, the idea that there was an admission here is not supported by the evidence. There was a stipulation that was entered into by Mr. Stuckich. You have that stipulation before you. That stipulation says nothing about an admission of any kind. It's on paper. It's in writing. Now, when there was a colloquy, we know, because I've included the order in the record appendix, that the colloquy concerned only whether the stipulation was signed knowingly and voluntarily. It didn't concern an admission of guilt. And to bring an ex-wife into the courtroom during a trial to say that he said something about sexual abuse and therefore it was an admission, and to enter it in front of a jury was just extraordinarily prejudicial. And that's really the essence of that.
Did the C&P come in as part of the Commonwealth's direct case, or was it after cross-examination by a witness?
I believe it came in as part of the Commonwealth's direct case, as did the restraining order, which again involved further determinations by a judge that the complainant was credible. And again, extraordinarily prejudicial.
Thank you, Mr. Shaw.
Thank you.
Ms. Alford?
Good morning, Your Honors. Pamela Alford for the Commonwealth. After thoroughly questioning the parties, the trial court allowed the school guidance counselor to testify as the first complaint witness. Because the trial testimony was consistent with pretrial representations, because the defendant never requested a voir dire.
May I interrupt you? We have this letter where the young lady says that my mom did not know anything about this, but I recently told her. So doesn't the letter indicate that before she communicated with Mrs. Horan, she had talked to her mother about this?
That is what the letter says.
Wouldn't that make the mother the first complaint witness, not Mrs. Horan? Just in terms of chronology.
Not in this case, because the prosecutor explicitly represented that what she was told by both the victim and the mother was that the first complaint was made to the school guidance counselor.
But then isn't that something that's in dispute based on what the alleged the complainant had said originally in writing and was before the judge, and so shouldn't there have clearly been a hearing? How can one decide?
Because the prosecutor made the representations of...
The prosecutor doesn't know anything firsthand.
She knows what she spoke with the parties.
The parties are very interested people at this point. They have an order roll.
This child, as far as I can tell, testified that she didn't want what had happened to happen. All she wanted to do was to prompt a divorce. She didn't want DSS involved. She didn't want a 51A. She didn't want any of that stuff, correct?
Correct.
So she may well not have anticipated what would have happened. She just wanted a divorce, correct? And then the thing spirals out of control. So why would we not expect that she and maybe her mother, not for any false reason, but just would say, well, that wasn't the case, when the letter itself said, I told her recently.
But I think we wouldn't expect it in this case, because during trial, both the victim and the mother, the victim testified at Volume 1, 263, that the school guidance counselor was the first person she told. The mother testified at Volume 2, 104, that she learned of the complaint the same day.
Did the judge ask, did anybody ask, it's your burden, what that statement meant? About, I told her recently?
The judge did inquire about the letter. The prosecutor admitted it.
No, of the child. Did anybody ask the child? Not the prosecutor. That's, at trial in front of the judge.
I do not believe anybody questioned the child about the letter. The defense counsel did question the school guidance counselor about the letter.
But she wouldn't have known whether or not this child had spoken to her mother beforehand.
But that could be a strategic decision on part of the defense counsel to get out the prior
defense counsel's burden.
Well, of course, the defense counsel doesn't want to go up and get into prior complaints, because that's not going to help his cause at all. So it's an impossible, you put the defense counsel in an impossible position. He can't, in the middle of the trial, say, oh, and did you complain to someone else? And she says, oh, yes. And then, yes, I complained to 8 other people. That's just what the defense counsel wants to hear.
But in this case, that was what the Commonwealth would suggest, a substantial part of the defense.
Why are you resisting that the judge could easily, faced with this evidence, it's in writing and it says, I recently told her, why couldn't the judge have just had a tiny mini voir dire and said to this child, did you tell your mother?
Because the defendant never asked for one.
But it's the Commonwealth's burden. If the Commonwealth wants a substitute witness, it is its burden, as is evident from the fact it filed a motion. I believe in this case the Commonwealth did file a motion,
That's
right?
correct.
So the Commonwealth recognized that it was its burden to present a substitute witness.
But they weren't suggesting they were presenting a substitute witness. I take it the Commonwealth's position was this is the first complaint witness. This isn't a substitute.
That's correct, Your Honor. To answer a question that came up in my brother's argument, the Commonwealth did say that the judge has discretion in cases of substitution, but the primary argument was that the evidence that the Commonwealth had to present was that the school guidance counselor was the first complaint witness.
Could I interrupt you just for some clarification? When you say that Mrs. Horan was the first witness, first person that this young lady spoke to, as I understand the facts, first came the letter to her, then came a conversation. Is that right?
That's correct.
She put the letter in her mailbox and then the next day met with Mrs. Horan and the principal.
That's incorrect. There were the first complaint that the Commonwealth presented was that the victim told the school guidance counselor that she was leaving something, I believe, the next day for her in her mailbox. The next day, the school guidance counselor sees the letter. She brings the victim into her that day. They meet. The testimony was that there was not further disclosures at that time.
Now, wait a minute. Had the guidance counselor read the letter before she met with this child?
She had to have. Otherwise, there wouldn't have been a meeting.
It would have been implicit from the evidence. I suggest that she
Why
did.
is the letter not the first complaint?
The letter the Commonwealth suggested was part of the first complaint, but that the first complaint existed over 2 days. The meeting with the principal that was suggested was actually a second meeting after the victim, on the first meeting, the victim said, "I have never writing for you." They agreed to meet the following day. They met the following day. She presented the writing. The only evidence at trial was that the principal was there, not that the principal participated in a meaningful way. The Commonwealth's evidence was that the first complaint were these 2 writings and these 2 conversations with the school guidance counselor. That is how the victim made her complaint known.
Did the child's mother testify at the trial?
She did.
Was she questioned about whether or not her daughter had told her anything?
She testified that she first learned of the complaint the same day as the guidance counselor.
Why is that relevant? What is the basis for eliciting that evidence?
The basis for eliciting that evidence was to set up the family meeting that occurred afterwards where the defendant made certain admissions.
Why couldn't the Commonwealth just have said to somebody, the child or the mother, as a result of what happened with the guidance counselor at school, was there a family meeting? Or did something happen as a result of that? The answer, yes. What? Family meeting.
These other disclosures were not first or fresh complaint disclosures because there was no content.
That's right. Then why were they admitted?
All the same interview, they're going to the police station, forensic, same. What is the relevance of that?
The relevance that shows the Commonwealth, the course of the Commonwealth investigation.
What is the relevance of that?
It defeats an argument that the police did not investigate it. It shows how the
That
case...
argument made?
It defeats the... It shows how the
Was
case...
done on direct or rebuttal?
It was on direct.
And so how could it defeat anything? Because there hadn't been any such claim. Was there a claim made by the defense?
The claim made by the defense was
Now,
that...
was there a claim made by the defense that the police hadn't investigated this?
No, but there was a claim that the victim embroidered her...
Forget embroidered. I'm just asking you so that to defeat a claim, that's not relevant in this case.
The case was about the victim... The defense case, the Commonwealth would suggest, was about the victim's credibility in her differing stories.
I understand that.
People come and testify, we believe her, we believe her, we believe her. I mean, not expressly, but implicit.
Certainly not, and the Commonwealth suggests that's not what happened in this case. The school guidance counselor testified she had the file of 51A. There was no self-corroboration here. It was clear to the jury...
Why was the fact that there was a 51A even admissible? What's the relevance of that?
The relevance is...
Why should the guidance counselor have been permitted to testify that she had to file a 51A? That has no relevance, has nothing to do with the case.
It does show what happened when...
No, it doesn't. It shows that she drew a conclusion.
I guess what we're saying is the Commonwealth can't get through the back door a whole lot of stuff that would be prohibited as first complaint evidence.
Certainly, in the Commonwealth...
Nor can they use the term, quote, police investigation or investigation of the complaint to get a lot of irrelevant information there. Same interview, 51A complaint, maybe even the domestic abuse order, all those kinds of things.
This evidence was not objected to, and the Commonwealth suggests clear that there was a strategic reason to do so. The 209A order, the judge in...
Well, there are two things that happen. One is, should a defendant object, and the other is, why is the Commonwealth trying to get it in? It cannot be that the way we conduct fair trials is the Commonwealth tries to get an evidence that is clearly irrelevant, and just if the defendant doesn't object, that's okay. Correct? I mean, we have to look at a substantial risk of a miscarriage of justice. So if we decide that the evidence was not relevant and shouldn't have been admitted, there may well be a substantial risk of a miscarriage of justice. I don't know that. I haven't looked at the record. So the Commonwealth doesn't have any interest in getting evidence, in getting statements into evidence, that are objectionable, even if the defendant doesn't object. Correct?
Could you... I didn't quite understand the question.
On appeal, even if something is not objected to, we look at it for a substantial risk of a miscarriage of justice.
Correct.
So the Commonwealth has no interest in having evidence that should not have been admitted in evidence.
Correct.
Okay.
Would you agree that if we accept the statement in the letter to the guidance counselor, I recently told my mother, that would make the mother the first complaint witness, not the guidance counselor? And then, in order to have allowed the guidance counselor to testify, that the Commonwealth would have had to show that the mother was unavailable, incompetent, or perhaps unable to testify for some reason?
No, because not only did you have the mother's testimony that she learned of the complaint from the guidance counselor, you had the victim's testimony that the first person she told was the guidance counselor.
So then we would have to ignore what she wrote in the letter, wouldn't we?
You would have to treat it as a prior inconsistent statement. A statement that the defendant could cross-examine the victim on.
But before we know anything, we have to have the benefit of a hearing before the judge so somebody can make a decision. But let me ask you another question, because I think we're beating a dead horse at this point. But can you explain to me why the Commonwealth put in the evidence about the prior care and protection hearing?
The evidence was of an admission by the defendant that he was there because of the sexual abuse of his daughter.
Does the record show that a defense attorney, and you've heard what he said this morning, and what do you say in response to that? He says that there was nothing about an admission in the stipulation at all.
In the stipulation is relevant to show that he was there at the hearing, that he participated in the hearing.
All right. He was there. The mother could have gotten up and testified he was there. But so why does the content of the stipulation have to come in? You could just say, was there a stipulation or something like that? Or
the stipulation came in to corroborate the testimony of the mother that he was present and participated at the hearing. The statement that the mother testified to was the statement of a party opponent, improperly admissible as such.
In the stipulation, did he admit guilt?
No.
So
it's the mother's testimony as to what the defendant said in the course of that proceeding when he was examined by the judge.
That is correct.
Was a transcript obtained?
The Commonwealth, no. The Commonwealth attempted to obtain a transcript, discovered that the tapes had been destroyed in the normal course of business, and had a letter from the juvenile justice to that effect.
So he was there. So what happened at that hearing, in care and protection hearing, that was relevant to this case?
That the judge asked him if he understood why he was there.
Okay.
and that he said yes. And when asked why, he said the sexual, I believe the testimony was words to the effect the sexual abuse of my daughter.
So
That's
he
why everybody was
understood
there.
that he was there at the CMP hearing because of sexual abuse of his daughter.
It's not
But that doesn't mean
necessarily.
that he was admitting that the allegation was correct.
Well, on cross-examination, the defendant asked the victim again, and the victim clarified that he said his sexual abuse of his daughter.
You mean the mother testified to
The mother testified, yes.
Well, yes, but it's something.
He was contesting the hearing, wasn't he?
No, he wasn't. He was stipulating to determination of his parental rights.
But he said he was doing that because she was 16 or 17 and she was soon going to be 18. Didn't he say that?
He did say that, and that's a fact that the jury could consider in assessing the credibility of the witnesses. But
But didn't he also say that he was doing it because he didn't want to put his daughter through a trial?
He did say that, but that doesn't.
It's all getting into a very collateral proceeding, and he's saying what to who, like, and why? I mean, why is that all relevant?
Because it's a statement of a party opponent, and the meaning and the effect of that state. Yes, but precedent does generally, as the Commonwealth understands it, statements of a party opponent are admissible, and the meaning is what the jury has the capability to assess. I see that my time is up. If there are no further questions.
I just have one. In a case like this, and this is on another subject, the district attorney asked the father, after the father said something about, he didn't on direct examination, as I understand it, the father said something about he didn't understand why his daughter was bringing these charges against him. And the district attorney then started to ask him something about whether are you saying the daughter was lying? Now, that's clearly improper. I mean, don't you agree that it's improper to ask a witness if another witness is lying?
It is, Your Honor.
Okay, and you would concede as much in your brief. Why are the prosecutors doing something like this in a case like this?
That is a question I cannot answer.
Well, I suggest it might be beneficial that if there was some education of prosecutors so that they didn't ask questions that the Commonwealth has to concede on appeal are error.
Yes, Your Honor.
Thank you, Ms. Orford.